Good afternoon. I am Molebogeng Mokhomotsi, and I will be your host for today's session. The South African Bar Association hosts bi-weekly sessions where we invite a speaker in the legal fraternity to share with participants on any legal subject. The purpose of these sessions are generally to connect the legal fraternity locally and internationally whilst engaging on matters that relate to the legal profession, not just locally, but also internationally. Before we commence, some housekeeping rules to just ensure that everyone understands how we're going to conduct the session. Please just make sure that all your videos are switched off at all times. Ensure that your microphones are muted. And, okay, sorry, I just noted something. All right, ensure that your microphones are muted. A Q&A session will commence soon after the presentation, and you will be given an opportunity to ask a question. You can either raise the icon in the Teams platform or just put your question in the chat bar. Without further ado, our esteemed speaker today is Advocate Romeo Nthambeleni SC, who will be speaking on the topic, Making Law Great Again. A quick bio before we commence. Advocate Romeo Nthambeleni is an admitted advocate of the High Court of South Africa with over 20 years in the legal profession in various roles in academia, practice, and the judiciary as an acting judge at the Pretoria High Court and recently the Western Cape High Court. He is a group leader for the High Court Chambers in Cape Town, which is a transformation initiative at the Western Cape. He holds an LLB, an LLM in commercial law, and various postgraduate diplomas and certificates from South Africa and abroad. He is currently an LLD candidate in competition law. Romeo is a certified and accredited business rescue practitioner with the CIPC of South Africa. He is a council member of the African, the South African Bar Association, and the Legal Practice Council of South Africa. He is the founder of South Africa Legal Practitioners Association, Johannesburg Chambers of Commerce, Johannesburg Chambers of Commerce, to mention a few of his affiliations. He is a presenter for motion court proceedings for pupillage at the South African Bar Association. Ladies and gentlemen, I sure hope that you enjoy the session today, and I'm now going to hand over to our guest speaker. Thank you.
All right, thanks for that introduction, Olebwe. I really appreciate that. Okay, today basically we are going to speak about ethics in our profession. And July, may you please do us the honors of lifting up the presentation for us to be able to start with the presentation. Okay. Firstly, I just want to get to the gist of things. What you see there is supposed to be, a document that is being written to the other side, by, a party who is a litigant on the other side. And I want us to look at the language that is used in this document. The claim of the plaintiff is bizarre, to say the least, and the plaintiff claim is based on the fact that his wife had an extramarital affair with someone while working at First Rand Bank Limited. The plaintiff claims rest on the premise that First Rand Bank Limited are somehow responsible for his pain and suffering, and as a result of this affair. I know that the litigant can be imaginative here in Johannesburg, but this is one of this one deserves a special prize. There is no such claim recognized in our common law. I'm quite confident that no matter how much judges in this division may try to develop the common law, we are not in this country going to start allowing awards of damages against employees because people fall in love while they're at work. This happens all the time. It happens and will no doubt continue to happen until the cows come home. The exception is well taken. The defendant has now applied for a postponement on the basis of indisposition, but I fully agree with Advocate Rose who appears for the excipient that there is no point in procrastinating this matter and there is no point in prolonging the pain and agony. Thank you very much, July. We'll come back to this slide later. let's go to the main presentation. All right. Okay. All right. No, and then let's go to to the next page. July. Let's skip those qualifications. Okay. No. Today the main point that I want us to look at is the profession of advocates, and what the profession of advocates entail, and ethics for advocates. And it's quite important that we need to look at this issue now, because where we are at the moment, we are really scraping at the bottom of the barrel, and we need to reorganize our house in order for us to have a proper practice of an advocate in the country in various courts. So in the past, under that act, the Admission of Advocates Act of 1964, the advocate profession was a straitjacket, because you used to have advocates who are only referral advocates. And now the situation has sort of changed, because we have got the new act, the Legal Practice Act, that allows advocates to practice with a Fidelity Fund certificate. Can you go to the next slide? So the Legal Practice Act has brought in a new era of new advocates who are normally referred to advocates, who are advocates with Fidelity Fund certificates and are able to take lay instructions from the clients. And there's nothing wrong with that. And I was one of the great proponents of advocates to actually have Fidelity Fund certificates for obvious reasons. So while the previous dispensation created what was referred to as court-brook advocate, because a court-brook advocate is that advocate that was admitted and was not required to do pupillage. The reason was that an advocate profession was allowing people that were coming from foreign jurisdictions to actually come and practice, and the requirements that were onerous, in relation to compliance with pupillage, was not a requirement for people that were coming from other jurisdictions. So there was an admission of advocates, and the requirement was an LLB degree as a requirement for that admission. Now that has been done away with, and then there are new challenges that have been presented by the new Legal Practice Act, and then we will deal with it in the next slide. So I've already said that there's nothing wrong with an advocate who practices with a Fidelity Fund certificate. As in their own words, they are cutting out the middleman, who is an attorney who instruct referral advocates through briefs. But there is an ethical dilemma of attorneys seeing these advocates as the competition, and these advocates wearing two hats, as I've referred to them as advocates. So that analysis is completely wrong, and I don't agree with it, because the advocate with the Fidelity Fund certificate operates like an attorney with the right of appearance. An attorney with the right of appearance can appear in any court, without any exception, because they have the right of appearance. So I think that is the very same thing that is happening with the advocates, because like I've said, that attorneys have been having their cake and they've been eating it, so they cannot be taking with both hands. So that's why I was a great proponent of advocates with Fidelity Fund certificates. Let's go to the next slide, July. So the dilemma for the advocates with the Fidelity Fund certificate is the nature of practice and the location that they are required to practice. To practice with referral advocates for obvious reasons, practical reasons, as correctly set out by the Legal Practice Council Act, the Legal Practice Act. The legal LPC said, when you are an advocate with the Fidelity Fund certificate, you cannot practice with advocates that don't possess that Fidelity Fund certificate for obvious reasons, because it becomes impractical, because you serve as an office of an attorney where there will be service, and there will be a lot of people and direct members of the public that will be approaching your practice. So the other predicament which these advocates are facing is the taking of senior counsel. The LPC is facing a conundrum, as this process is managed traditionally by bars where peer review mechanism is employed to identify people that are potential to be senior counsel, and then that senior counsel status is given to them. So a lot need to be amended legislative wise in order to accommodate this new breed of advocates. For example, I'm talking about the power of attorney there. In the past, you know that the rules speak about the power of attorney. So the question that we have posed is that will there be a new power of advocates holding the Fidelity Fund certificate? That is an important question which one has to ponder under those circumstances. And then also the issue of discipline. It's a very critical issue to the LPC, because now the advocates that are members of the bars, when there's discipline issues concerned, are they going to be disciplined by the LPC, or are they going to be disciplined by their bars? And these questions, we have presented them to the LPC previously, and the LPC could not answer these questions as to what happens to the double jeopardy that will be suffered by advocates that will be members of the bar and also being disciplined by the LPC. So let's look at ethics today, which is an important point of what we are talking about today for advocates. I've already said that for the past 10 years, we are really scraping at the bottom of the barrel. In what was previously referred to as the noble profession. Is the profession still noble to get the jury is still out to answer that question. Practitioners have gone rogue, both attorneys and advocates alike, and there's no longer honor and decorum that is required within the profession. It's about kicking the can down the road, and while you do that, you are insulting the judges and the opponents alike. So myself and I was being led. Lebo, thanks very much. I'm waiting for my latest patent from the president to be confirmed as a senior counsel. So I'm technically not a senior counsel. I'm still a junior. So I was in a matter being led by a senior counsel, a very, very senior counsel at the Johannesburg Bar, which I respect. And on top of that, this senior counsel was a lady. And when we were dealing with this matter acting for the president of the Republic, we were being insulted by our opponent at all levels. We were called Askaris, we were called all these names because the advocate that was representing this client did not have a case, and he resorted to insults, in insulting me, and I was not really taking kindly to the insult, but the senior counsel who was leading me in the matter said, you know what, let's wait for the record, it will bear us out. And if you go through that record and read and see what has actually transpired in the record, you will be ashamed to be a member of this profession, because not only we were being insulted, the chairperson of the inquiry was being insulted. Our opponent was singing, literally singing revolutionary songs on record. It's there, So you ask yourself, a question as to, have we really gone, rogue to that level? That when no longer decorum is respected among colleagues and practitioners alike. So let's look at case laws. Some few case laws that comes to mind when we're dealing with these issues. We are aware of the matter of Tefu versus the Legal Practice Council of South Africa, and the importance of advocates and ethics in the profession in terms of how they present themselves in court. There is a certain language that is used in court when you are properly trained, when you are addressing the judges, that you cannot use it in an open court. And this is very, very much important. How you treat your own colleagues, how you use your language when you're presenting with your matter, it's very, 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 very much important. We always say that when you are prepared for your case, you argue your case and you will not argue your opponent. So no, there is a matter of Van der Berg. This matter went to the SCA in 2007, and then the SCA confirmed this striking off of a senior advocate of more than 30 years, no standing. What happened with Van der Berg is that Van der Berg recently tried to come back at the Western Cape High Court, and he applied to be readmitted into the profession in the Western Cape High Court. And the judges dismissed this application solely on the basis that the character deficit that has been identified by the SCA is still there, and it has not been corrected. So you must remember as practitioners that the moment you are struck off from the role, then readmission is a reverse onus on the applicant, who must demonstrate that the requirements of being a fit and proper person have been satisfied. So that is something that must always be in the back of your mind, that once you are struck off, the onus is on you to prove that you are fit to be readmitted into the profession. Let's go to the next slide, July. Then there's a matter of Vacha versus the Society of Johannesburg Society of Advocates. In this matter, the applicant had previous convictions for theft and escape from custody. He was sentenced to 6 lashes for shoplifting in 1989 when he was 16 years old. Subsequently, he was sentenced to 2 years imprisonment for escaping police custody around 2002 when he was 29 years old. Let's go to the next point. He participated in a robbery in which instruments were brandished. The robbery was not prosecuted due to lack of evidence. Mr. Vacha sought to be admitted as a legal practitioner and be enrolled as an advocate. Next point. Our DJP, Sutherland, dealt with the legal requirements for a fit and proper test for admission as an advocate to deal with the question on whether the applicant has established what fit and proper test requirement requires. The court came to the conclusion that in light of the history of the applicant, he was prima facie unfit to be admitted, as it was incumbent upon him to adduce evidence to rebut the inference that he is not a fit and proper person. And then there was an issue relating to his offenses. And on 2 occasions, under oath, he misrepresented the true position and the account that was supposed to be given for the commission of the crime. Then in this matter, the court came to the conclusion that there has been a clear failure to give a full and open account to show the applicant's inability. The court says that shows the applicant's inability to appreciate the sacrosanctity and of full and frank disclosure, which is critical for an ethical lawyer's character. So these are the requirements which are still there, which you still have to actually comply with. He was refused admission as an advocate of the High Court, and this was a clear example that the courts will not countenance applications of an unfit candidate. Now the LPC, after this decision, has now made it a requirement for a police clearance certificate to be produced in order for the LPC to inspect and make a determination whether there's a criminal record against the applicant. It is important that candidates admitted that are admitted into the profession are vetted properly by both the BAS and the LPC, as we have also witnessed many qualifications fraudsters masquerading as legal practitioners as well as doctors in South Africa. So it's important that that is done. And then there's a matter of a Legal Practice Council of South Africa versus Mkhize. This one is very interesting. The complainant here was Ms. Nkala, who complained to the LPC because she has paid Mkhize on 3 occasions and he failed to deliver what he was paid for. And as a result, she lost her home, which a grandmother has left for her. 5 additional complaints were received that Mkhize, who practices as an advocate, has accepted instructions directly from the public without holding a Fidelity Fund certificate, as required by the LPC, as discussed earlier. The application is by the LPC to suspend Mr. Mkhize or alternatively strike him from the role of practitioners. Then what ultimately happens was that the hearing commenced with Mr. Mkhize wearing a senior counsel's robe. And the counsel for the LPC pointed it out and contended that it is fraud and misrepresentation on the court to wear a senior counsel's robe when one is not a senior counsel. So a further misconduct was that Mr. Mkhize failed to practice as a referral advocate. The LPC central allegation was that Mr. Mkhize accepted instructions and deposit from clients without an attorney, and that is in contravention of Section 34 of the Legal Practice Act of 2014. Let's go further. In addition, he is accused of engaging with his opponents and writing letters on behalf of his clients. His defense was that his administrators accepted money without his approval. And the court said this is a lame excuse, as counsel cannot avoid responsibility by hiding behind the people that actually assist him. And funny enough, the court said in this matter, this monies that were being deposited landed in his account. The court said instead of coming clean as an officer of the court, Mkhize chose to attack the LPC instead of addressing serious allegations that were brought against him, and his obstructive and abusive attitude persisted to the very end as he treated orders of the court with contempt. Next, he makes false allegations as if he has received the latest patent when he has not. His conduct remind me of the scriptures in the Holy Bible, Romans chapter 6, verse 1. Shall we continue to sin so that grace may abound? Surely not. His conduct cannot be countenanced. And this is what the court has actually said. In this profession, every advocate worked out their own salvation in fear and trembling. In this case, Mkhize misconducted himself repeatedly and egregiously. The court concluded that he's not a fit and proper person to be enrolled as an advocate of the High Court, and ultimately he was struck off from the role of advocates. The victims of his conduct were members of the public who were elderly, and then the court noted that many of these elderly people were over the age of 60, who have no distinctions of knowing in our profession who is an attorney and who is an advocate. The duty is on you when the person is approaching you as an advocate. If you don't have the Fidelity Fund certificate, to make it clear to that person that I don't hold a Fidelity Fund certificate, so that they will be able to be referred to the attorneys. The court struck him from the role. In this matter, the court made sure that the unsuspecting members of the public can barely make a distinction. I've already said that between attorneys and advocates, and they need to be protected. And this is a lesson to all of us. The onus lies on you. Preparation in court versus arrogance. I say that a bad attitude is like a flat tire. You can't go anywhere until you change it. Arrogance is not a good currency to trade with in the legal profession, and the consequences are bad and they are dire. It is important for counsel to prepare for their matters properly before appearance in any court. The issue of lack of preparation is being moaned across the countries in all levels. Recently, we had a constitutional court judge dealing with the very same issues of seniors that are appearing in the council, in the constitutional court, being unprepared. I've seen many of your colleagues, both in the Pretoria High Court and recently in the Western High Court or Cape High Court, coming to appear when they are not prepared. An unprepared counsel is a recipe for disaster for his case, the court and his opponents. It is important that counsel is well au fait and well prepared with, and well read, and also knows the practice directive of his division at all material times. We can never overemphasize this point. You will never buy experience, and where you earn a reputation of unpreparedness, you will become known to the judges and the opponents alike. And that is the take that the counsel should avoid to carry at all costs. So there are times when counsel is not favored by the law and the facts. That is when preparation and presentations become key. Because you might be a great orator, but when the law and the facts are not on your side, you will end up on the losing end, and you will end up making submissions saying and so on and so on and so on and so on in court, embarrassing yourself. It is better to lose a matter with dignity than to insult the court and your opponents because you don't have the case to argue for your client. Next, July. The cardinal sin of technology and ChatGPT. It is important to take cognizance of the fact that you cannot replace the good old-fashioned method of research through books and library, but the technology is here to aid us so that we will be able to advance, not to embarrass ourselves. So unfortunately, law is all about research and presentation. Those are two key things in law. A regional court matter of Parker illustrates this very well, where reliance in technology can have dire consequences, wherein a council made submissions and submitted authorities that were sourced from ChatGPT, and those did not exist. This is what the position was. It is important to take cognizance that at paragraph 86 of that judgment, this is what was said. At the hearing on the 22nd of May, the plaintiff counsel explained that his attorneys had sourced the cases through the medium of ChatGPT, and then they define what ChatGPT is all about. There, you can look at ChatGPT later. Let's look at the next point, July. Then the plaintiff attorney used an artificial intelligence media to conduct legal research and accepted the result that is generated without satisfying themselves as to the accuracy. As it turned out, the cases listed above do not exist. The names and the citations are fictitious. The facts are fictitious, and the decisions are also fictitious. The plaintiff counsel was constrained to concede as much. Next, July. The defendant's counsel submitted that this type of an attempt to mislead the court must be met with an appropriate punitive cost order. And the plaintiff attorneys used artificial intelligence medium to conduct research and accepted the result that is generated without satisfying themselves as to the accuracy. As it turned out, the cases listed do not exist. The names and the citations are fictitious, and facts are fictitious, and the decisions are also fictitious. The plaintiff counsel was constrained to concede as much. And then the defendant's counsel submitted that this type of an act was an attempt to mislead the court and must be made with an appropriate cost order, punitive cost order. Next, July, I think we repeated this slide.
Yes, I think this is the end of the presentation.
Okay, it can't be the end, because on my side the presentation still I think had two slides, but it's fine. Let me allow Uleweng to take the floor and welcome the questions while we'll continue with our discussions. I will present the two slides on my side. That did not get to you, July. Thanks.
Thank you, Counsel. There's a bit of a delay on my end. I'm not sure if you can hear me.
Yes.
All right, welcome to everyone who joined us a bit later on, because I can see now the number of people has gone up quite considerably. So this is the segment or the portion of the session where we take questions. So if you have a question, you have an option of either unmuting yourself, asking the question. You can raise your hand as per the icon on the platform, or you could just in the chat box, pop your question in there and I'll read it out and Counsel will respond. Thank you. Let me just check the chat box. It doesn't seem like the...
Yeah, okay.
But I'm also receiving messages on.
Okay. Yes. So that last slide that was not there on the end of July side was that the plaintiff attorneys used the artificial intelligence medium to conduct research, and then from there, however, the plaintiff's legal team did not submit these cases as binding authorities, but they submitted them to the defendant. That is what transpired in that matter. Then this is a serious lesson to advocates that don't take authorities that are supplied by attorneys on face value without verifying them. And that was the last part of the slide that was not shown by July. So as counsel, you have the responsibility of verifying the authorities that if you did not conduct the research by yourself, the cases and the authorities that are being presented by your attorney, please verify them before you make submissions in court. That is extremely important, because you don't want to be found on the side that you are misleading the court when you did not verify the authorities that you are submitting to court. It's very, 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 very much important. We cannot overemphasize that. And then the courtesy to you as practitioners is quite important. Last month when I was sitting at the Western Cape High Court, this is what happens. I get to court in the morning and I'm prepared to go to court, and my clerk tells me that, you know what, I've received an email by one of the counsels in the matter. She says that the court must start at 11 o'clock. And I was surprised and I was taken aback. And then I get to court at 11 o'clock, which the counsel has called that the matter must come at 11 o'clock. I asked the other side, did you communicate with each other about the court starting at 11 o'clock? The other side said, no, we were not aware that we are supposed to start at 11 o'clock. So this counsel that was appearing on the other side made a decision on their own. Then made a presentation to my clerk, and then the matter was supposed to be heard, and then we had to sit, and the court had to wait for her. She decides when she's going to be heard. When I ask her, why are you actually doing that? Because you're not supposed to do this. They said, no, I took on a lot of matters and I was late, and at the end of the day, I wanted us to start late and all that. And she was just giving a lot of reasons that were unacceptable. And I said, you know what? It is better to come to court when you did not bath than to make the court to start at the time that you actually chose. It's completely unacceptable. So you find this this conduct, and you're dealing with opponents who are like that, who are unprepared. And there are points when I was listening to matters, and you will hear that, you know what, the other side does not have a case, but the manner and the way in which they are presenting their matter, they deserve to be heard, and this matter is being presented to court with dignity, respecting the dignity of the court and the decorum of the court. And that is why this profession is important. And the ombudsman recently complained about the conduct of the practitioners in court. The Legal Practice Council is complaining about the conduct of the practitioners in court. And judges will find a method of fighting back. And their only method of fighting back is to report you, for the investigations. There are other matters that I did not refer to, like the matter of Gadabeni, which went to the LPC, and he was struck off from the role when he was appearing in a matter, and the facts of the matter in the case were not in his favor, and he made an argument with the judge, telling the judge that he's stupid on record, saying to the judge, you're stupid. You don't know what you're doing. And this is the kind of practitioners that we are actually breeding now. The practitioners that don't respect the decorum of the court, the practitioners that don't respect other practitioners. When your case is not a proper case that is before court, then you attack the judge, then you attack your opponents without any basis whatsoever. It's completely unacceptable. And this is the kind of conduct that judges are seriously on a lookout for. And you don't want to be found on the other side.
Thank you for that, counsel. Indeed, there's a question in the chat box from A. Manonga. The question is that It's regarding the amendment, and the question is that has it been rendered, or rather the one that rendered ex parte advocates inadmissible? When did it come into effect? And did this affect the status of those advocates who admitted before the amendment?
Okay. No, thank you. Thank you for that question. The status of the advocates that were admitted prior, no, it was not affected, because those advocates that were admitted in terms of the 1964 Act were properly admitted, and they met the requirements. And previously, as I've stated, that it was not a requirement for an advocate to be admitted and do pupillage. Hence, you found that there were advocates that were admitted without having done pupillage. And now the issue of possessing a fidelity fund certificate became important, because there were advocates that were practically admitted, and they were doing criminal matters. And when they do criminal matters, you will find that an advocate needed a brief to appear in the magistrate court. And I said, this is unacceptable. You cannot have an advocate seeking a brief from an attorney to go and appear to represent his client on bail. So we said no. Advocates, those that want to practice with fidelity fund certificate, must be granted fidelity fund certificate, so that they will run a seamless practice without seeking instructions from anyone else. So those are advocates that were admitted prior are properly admitted, but the advocates that are admitted after 2014 are the ones that are admitted after these dispensations that either chooses to practice with a fidelity fund certificate or without a fidelity fund certificate. It's still an election that you still have to make yourself in terms of how you want to run your own practice as an advocate with a fidelity fund certificate or without a fidelity fund certificate. When you have the fidelity fund certificate, you are required to go through some courses on how to manage your books and do all those things that are required that attorneys do. And if you don't have that, then you will not be able to practice. You cannot be a referral advocate and take direct instructions from from the clients. That is the Mkhize matter that we were looking at now. Mkhize was a referral advocate, and then he took instructions directly from the members of the public without possessing the fidelity fund certificate. So a fidelity fund certificate is a requirement for those advocates that want to have access directly to the members of the public. It's very important.
Thank you, Council. I hope they're satisfied with your response. There's another question coming in from Dumisa. It says, good afternoon, Council. Informative presentation. How far has the LPC responded on the issue of the double jeopardy when dealing with the conduct of practitioners? I suspect they may follow the disciplinary process followed by most departments, where one is charged departmentally and by direct entities.
Yeah, Dumisa might be having a point. The issue at the LPC is that the LPC cannot actually give us some critical answers to these questions that we are presenting today. We called them here and we asked them to conduct a presentation for us, and they couldn't give us a clear answer as relation to that question of double jeopardy, as whether when you are a member of the bar, you are disciplined by the bar and both by the LPC, because that will create a problem in future. So let's hope that they will resolve it in that manner.
Thank you, Council. Another one from Advocate Mphohla Hanning. Good afternoon. According to my understanding, the principle of fit and proper status is a standard the court upholds and not necessarily legislated. Suffice to say, the LPA merely provides a definition of fit and proper. My question is, why is the principle not entrenched in law? In other words, why is it not legislated, considering the detrimental effects it has on practitioners and prospective practitioners?
Okay. No, good question by no, thanks. He's correct on one point, but there is a point which is important that he missed there. The fit and proper test has been the standard has been determined by the courts. I'll give you an example of what a fit and proper person is. When you have a previous conviction of any nature whatsoever, we talk about that reverse onus of saying that you have to then show to the court, if you are seeking an admission, that you are a fit and proper person to be admitted as an advocate. I've previously admitted candidates that had previous convictions successfully, so because as our DJP indicated, they were able to be frank to the court and present the facts that show the court that they are fit and proper to be admitted as advocates. So the standard of fit and proper is set by the case laws that have been tried in our law, that were confirmed at the Constitutional Court, that were confirmed at the Supreme Court of Appeal, as to what is the test of a fit and proper person to be admitted, either as as a practicing attorney or as a practicing advocate of the High Court. So when you look at those matters, if you look at the the Tefu matter, if you look at the Vacha matter that I've referred you to, if you look at the Garabeni matter, the court says, set out that that standard to say this is a standard that we expect for a fit and proper person to be admitted as an advocate of the High Court. And if you don't meet this standard, you're not going to be admitted as an advocate of the High Court. Then, if you are an advocate and you are practicing and you are found to have breached one of these requirements, it means that you are falling short of the standard of being a fit and proper person to practice as an advocate. So that is the position in relation to Mpho's question.
Thank you, Romeo. I have a question here. It's from Laura. It's not in the chat box. She sent it to me directly. Question is that, how do we deal with the issue of counsel who didn't do pupillage and didn't receive appropriate induction? How do we tackle the issue of them coming to court unaware of certain court rules and how procedures work, such as waiting for seniors to go first?
Okay, what does she say about waiting for seniors to go first?
She's saying, so primarily what she's trying to understand here is, how is the issue of advocates that didn't do pupillage, who do not fully understand how to conduct oneself in court, how is that dealt with, or how do we circumvent such situations from occurring? Because it is commonly seen that some are clearly unaware of decorum and such. For example, waiting for seniors to go first. She just used that as an example.
Yeah.
How do you deal with that, or how are we supposed to?
No, I think all these various bars have to sit and come with a resolution to assist the LPC on how to to deal with these advocates that are not properly trained. And in our bar we have made it open that.
So forgive me to interrupt you, Romeo.
Yeah.
Forgive the interrupting, or I'm using my phone to connect to the presentation, and I'm unfortunately not able to raise my hand. So I can wait until Romeo has answered, but I would like to respond to that question as well.
Noted.
No, it's fine. Let me give Bart for the opportunity to to answer. Then we'll proceed there.
Yeah, if I may, I think one must understand that through no fault of their own, we have some advocates who would have loved to have done pupillage, but who, given the fact that the bars who operated at some point were very exclusive, both in terms of who they allowed and the individuals them they sought to attract. So what would happen is a person would for years and years apply over and over and over and not be accepted for pupillage, but be an admitted advocate. So the difficulty that a person like that would have then have is that they want and is eager to continue practice or get involved in the practice, but they are disallowed to do so because they haven't done pupillage. So you have a number of advocates who are practicing at the moment who haven't done pupillage. And that exclusion is then further imposed on them because now it's said that you can't even join a bar if you haven't done pupillage. So what we've done as the South African Bar Association is we've come up with a system that we're going to be implementing to assist such advocates, to bring them up to speed in a program that we refer to as our legal competency assessment program. And that program will assist those specifically advocates who haven't had the opportunity through no fault of their own to do pupillage, but who are finding themselves in a situation where they're currently practicing. So we will be rolling out a fully fledged program from next year onwards. And the person who's spearheading the development around this is Dr. Dexter van Reineveld, insofar as what do we mean by legal competency assessment?
Yeah, no, thank you very much, Bart and Uleweng. I think that clarifies that the position. And then I think the last question which Laura was talking about is about etiquette and waiting your turn. 10 years, 15 years ago, you were not going to even dare go and sit in front when you're not supposed to sit in front. You wait for your seniors to first call their matters, and then you will be allowed an opportunity for your matter not to be called. You will never stand up out of 10. That was just the rule of thumb. Anyone who has done privilege, who was properly trained, we will know you. And in the past, you will stick out like a sore thumb. If you haven't done privilege, the judges will want to identify you. They will ask you, where do you come from? And people used to feel like they were being victimized. And the judges will ask the questions, which bar are you coming from? And then they will tell you, this is not how we do things here. Please, wait. This is how we run the court. So, practically, practitioners that are practicing know each other, and then they know who has admitted before who did what before who, because even the level of seniority in terms of senior counsel differs. There are very, very senior counsels, and there are very junior senior counsels as well. So they know each other in terms of the years and when were they admitted, when did one receive letters patent. The same group of the counsels that receives letters patents together, when they are in court together, they might stand together or allow each other courtesy to say that, you know what, call your matter, I'll call your matter after you. But judges recognizes the presence of senior counsels when they are in court. What happens is that how I normally run the role is that I will get in and I will get to check if there are any senior counsels. If I'm doing my motion, if there are senior counsels, we give the senior counsels first preference to call their matters. And when the senior counsels are done with calling their matters, then we'll look at the at the role, and then I will do it page by page. And then we start with the numbers. But I don't know how you run your own role. Maybe you can also come in there, Bart.
Yeah, thanks for that, Romeo. Look, it differs. When I sit in the labor court, given the fact that the role in the labor court is quite short, not necessarily meaning that the matters are short, I generally deal with my labor court role sequentially based on the numbering system that's allocated by my registrar, and that's how we then deal with it. What I prefer to do in the High Court when I sit there is obviously to give credence to seniority. So, like Romeo correctly indicated, you would obviously ask the parties to call their matters by seniority. And there's generally a sense of those who are more senior would generally congregate at the front end of the courts, and those who are less senior more towards the back of the court. And that's been a very noble tradition that we've upheld as members of the bar. And you must understand, when I refer to members of the bar, I don't refer to a specific bar organization or institution. The moment an advocate practices, he is a member of the bar. Bar refers to an advocate who's in practice is referred to as a member of the bar, not necessarily the voluntary associations that you belong to. So that's how I deal with it, Romeo.
Yeah.
And there has been an instance once where an attorney wanted to have his matter heard before me listening or hearing out counsel. And I respectfully said to the attorney, look, as matters stand, I'm first going to deal with counsel and then I'm going to deal with the attorney. But I did so respectfully. And no sooner had I done so, and a complaint was then raised that I'd somehow tried to insult the attorney or so. But it was not the case. It was simply that there's a certain decorum that we must uphold and observe when we deal with how we operate in court. And as practitioners, we must jealously guard and protect that decorum.
Yeah, absolutely. And I couldn't have said it much more better than that. But I think it is our duty to, observe our own decorum in order to preserve the ethics of this profession. Like I said when I started, that we are really scraping at the bottom of the barrel. When I was dealing with divorces in Cape Town, there were people that were coming to appear in T-shirts, and I said, "You guys think we are coming here to play tennis? I'm not going to grant a decree of divorce to anyone that is actually not properly dressed." And and then there was an attitude. He's bringing the Johannesburg attitude and all that and things like that. I said, no, this is unacceptable. I'm not going to allow it. When you come to court, previously you know that you must be properly dressed, for court. And then when you're not properly dressed, your matter is not going to be entertained. Go and try it somewhere else next door. So obviously, as Bart will say, you will be reported for that, but the record will bear you out, and you will hear the JP and the DJP saying, no, this is actually the standard. Everyone must comply and they must come properly dressed. It's unacceptable that you have been allowed to come dressed in any other manner whatsoever that you actually want. You dress like you're going to hunt at the book, or you're going to a picnic and you're coming to court. It is our duty as well as counsels when we are dealing with divorce matters to tell our clients, if your attorney has not done that, please do it as counsel, to say, please come properly dressed. There was a person.
Thank you. There's a question again from A. Mananga. Is the gravity of the offense that a practitioner may have been, or rather, let me read this. Is the gravity of the offense that a practitioner may have been previously convicted of an element of consideration in being deemed a fit and proper person?
No, absolutely. If you were involved in money laundering, and you want to be admitted, as an attorney, obviously, the bar is going to be very high for you, to persuade the court that you are a fit and proper person to be admitted, because you are going to be dealing with public funds. If you want to be admitted as an advocate with a fidelity fund certificate, and you were involved in money laundering, theft, racketeering, misrepresentation, the bar on your side is going to be lifted very, very high for you to persuade the court that, indeed, in terms of these offenses that you have been previously convicted of, you are no longer, involving yourself in that, and you have had a Damascus Road experience, and now you are a fit and proper person to be admitted as an advocate, and that is the requirement.
All right. And Mpoho says, thank you very much, Advocate Ford, for the initiative. I recently had a chat with some advocates from the Johannesburg Bar, and they shared that their concern is that SABA is allowing people who did not complete pupillage to practice. I suppose that's more of a comment than a question. But I suppose now Mpoho knows of the initiative that is being implemented, and we will all have an answer for anybody who is concerned of such.
All right, it's fine. Bart can deal with that. Bart, can you just attend that?
Yeah. As I indicated, one must understand that the standard, insofar as legal practice is concerned, is not determined by anybody other than the LPC. So the LPC is what sets the standard. So if the LPC says this person as an advocate can practice, whether or not that person has done pupillage or has not done pupillage, if the LPC says, or by the standard imposed on us by a proper interpretation of the LPA, that this person is an advocate and can practice. So prior to 2018, if you have an LLB degree and you were admitted as an advocate, you can practice for your own account. That is so. So what we do is, because there is this lapse in between those who have gone through pupillage and those who have not gone through pupillage, and this is what we're coming up with. We understand the benefit of having done pupillage. We do. There is a huge benefit that cannot be overemphasized. So what do we do with those who haven't done pupillage but are eligible and entitled to practice? And this is where the legal competency assessment program comes in. It's a program that's effectively similar to pupillage. You will go through the program. So even among some of the members who are practicing as part of our bar, those members will be ring-fenced, and we will say, you haven't gone through pupillage, but this is the program that we're introducing to ensure that you get the necessary training that you may not have been able to acquire through no fault of your own, and we're going to assist you. You have a similar instance in when you have your SETAs, your sectoral education training authorities, where an individual may not have done a formal matric qualification, but the person is assessed and RPL'd and assisted and is accepted that that person's experience or whatever training that that person may have gone through is the equivalent of what is considered a matric. And similarly, we're saying if you've gone through the legal competency assessment program, you don't need to leave your practice. You can continue practicing, but we're going to assist you in such a manner that you don't lag behind either insofar as competence or theory or knowledge is concerned. And to ensure that we upskill you in such a manner that you can competently stand before any court as if you have done pupillage by virtue of our legal competency assessment program.
Thank you very much, Bar. I think that clarifies, our mission, and our aim, is not to, to lower the bar or lower the standards. You can see our program is called Raising the Bar for a particular reason, and we will not want to have, with us within our rank and file people that are not properly, prepared, as Bart has actually said, to appear in our courts and present cases for their clients properly and without fear or favor or anything. So the standard has been set by the LPC, and ourselves, we are going to assist the LPC to assist those advocates that were in the past, not through the fault of their own, not able to do a proper pupillage program, so that they know what proper trial advocacy is all about, what proper drafting is all about, and presentation of matters in court, which is the function of an advocate practicing in any court.
Thank you for that. I have a question again from someone who is unable to type in the chat box. The question relates to baby juniors. How are baby juniors to tackle late briefs and thus having an adequate time to prepare? I suppose this touches on the issue of preparedness that you touched on earlier in your presentation, Romeo. Okay. There's often that situation where baby juniors are contending between gaining experience, by forced to take a brief that came in, the night before, or saying no and preparing.
That is very important, and it happens to to follow to all of us. In order for you to be able to properly swim, for those that know swimming, we have to throw you at the deep end. Then you will get those kind of matters, but let it not be a habit. All of us have gone through that process of getting late briefs. As much as you have received that brief late, it is your duty to actually prepare it and read it and move it to the best of your ability. But make sure that you communicate with your attorneys to say, what, please give me the briefs when there's still time, because you might find that in other briefs you need to properly consult with the clients. You need to verify the papers and check how the papers are drafted. I've shown you an example of the papers that were were drafted that have got an exception on them when we started this presentation. So you are, as counsel, you are not going to, as a referral advocate, you are not the master of your practice. You are not going to avoid getting a late brief. But try as much as you have received it to prepare it and present it to the best of your ability. And when the judges engage you and ask you, you can make a concession that, this is when, and I was briefed, and that is why I look a little bit underprepared. So that will actually help you when you are, moving your matters in court.
Thank you for that. Well, I've said that and it didn't quite help me.
Yeah.
But then again, it happens.
It's
just after 5 and it doesn't look like we have any more questions.
Yeah.
I just want to take this opportunity to thank you, Romeo, for making time to be our speaker today and for that informative session we just had with you. And to everybody for logging in and participating. We really, really greatly appreciate it. And we look forward to seeing you again in about 2 weeks' time, where we will be exploring a different topic with a different speaker. Thank you so much.
All right. Thanks. Thank you very much.